Hello, I am Arizona Lawyer Julie LaBenz. Welcome to my channel. I want to talk to you today about a very common mistake that self-represented parties make when they walk into family court. So imagine it's your trial day. You've either got a temporary orders hearing or you've got a final trial, but it's the type of hearing where it's your turn to present your evidence and prove your case to the judge. You're ready to go, you have prepared, and you start to testify. And you're talking about how you know the other side would have answered a certain way. You know you anticipate what your ex would have done under a certain set of circumstances. So you didn't make the effort to communicate with your ex or to ask the particular question. And what happens is that in that event, you're testifying about speculation. Even though you know how your ex would respond because you know this person very well, that is not sufficient evidence. So let me give you an example. You're testifying about how you did not offer your ex parenting time because you knew they'd say no. Or you didn't send a message to inform your ex about something going on with your child's school activities because they never show up anyways. The problem is when you're in that trial, your ex inevitably is going to say, well, if she had, told me about that, or if she would have offered me the parenting time, or if she would have told me about the school activity, I would have taken that parenting time, or I would have gone to that school activity. And then your evidence just fell apart. So what you want to do is you don't want to present speculative evidence to the judge. So even though you know what the outcome is going to be, you need to make sure to gather the evidence so that you're in a position to present strong evidence at your hearing. So what this means is that even if you're anticipating a particular outcome, because it's happened so many times in the past, and you know that your ex is going to act the same way, you need to be thinking about presenting your case in court, not about the emotional dynamics between the two of you. Send the text, ask the question, offer the parenting time, inform them about the activity. You need to have a clear showing that you offered the parenting time, that you told them about the school activity, that you asked them to contribute payment, whatever the facts may be, you need to make sure that you don't just say, oh, well, I know how they would have responded, so I never asked, because now you don't have the evidence to present in court. So this is a really easy fix because all you need to do is send that text, ask that question, write the email, whatever format you're going to do. Of course, having it in writing is best because then you have a very clear record of the communication. But make sure that you actually gather that evidence in a way that you're going to be able to present it at court. All right? This puts you in a position to present the text message as an exhibit. This puts you in a position to present the email as an exhibit, or at the very least to testify to a conversation that was had. And then you can show the text response or the non-response or the email response, or you can testify as to what the response was. Of course, having it in writing can make it stronger because then there's no opportunity for your ex to deny that the conversation happened. But you want to make sure that you gather that evidence by engaging in that conversation, even though emotionally you likely don't want to have that conversation. Although emotionally it may be very triggering for you. It may bring up emotions. It may lead to an argument. It may make you feel let down when the other side doesn't do what you perceive to be the right thing. And that's that's something that generally stops people from gathering this evidence. But if you want to have a strong case on a particular point, your best avenue forward is to engage in that conversation. Now, emotionally, you can start to protect yourself before you engage in it. You can obviously have a personal dialogue about what you're anticipating and about how, your emotions are valid, that you feel let down or that you're disappointed for your child because the other parent isn't stepping up. And you can certainly address those feelings by acknowledging them. But then I want you to put your, lawyer cap on, your self-representation lawyer cap, and I want you to go out and create the paper trail for that evidence. Now, as a bonus, I want to walk you through how you would present this particular text message as an exhibit at your hearing. Now, you will have already had this text message printed out and submitted to the court as one of your exhibits. You will have disclosed it to the other side, ideally 30 days before the hearing. So first step is to disclose it. And remember, disclosure just goes between the parties. Disclosure is not filed with the court. And then on or before your exhibit deadline, you'll submit your exhibit either electronically or hard copies, depending on whatever your court's procedure is. And you'll have it organized, you'll have it labeled, and ideally, you want this exhibit to show who, on its face, to show who it's from, who it's to, and the date. So if you're engaging in a long text thread, you may need to include, further back in the text where it shows the date of that text. If you're not able to do that, then when you name your exhibit, you'll want to include the date of this text exchange. If you have an email, that's much easier. It shows right at the top who it's to, who it's from, the date. So those are called foundational elements of the exhibit, but you can't just expect that an exhibit with no date or no showing of who it's between is automatically going to be allowed into evidence. So have those foundational elements, include that in the name of your exhibit. So for example, text message between petitioner and respondent on January 16th, 2026. So that's an example. Or email between petitioner and respondent on January 26th or January 16th, 2026. Okay, so you've disclosed it, you've submitted it as a piece of evidence, and now you're on the stand, you're testifying. And let's say that this is your exhibit 5, all right? So now you're ready to present this evidence. And you say, okay, I'd like to present exhibit 5. If it's an electronic exhibit, it's brought up on the screen. If it's a paper exhibit, it's brought to you as the witness. And then you explain what it is. This is a text message between me and the respondent from January 16th of 2016. Move to admit. Okay, so you've laid the foundation of what the exhibit is. It's a text message, who it's between, and the date of it. And then you move to admit it into evidence. Once the judge says that it's admitted into evidence, then you can read what it says. All right. So you describe what it is, you move to admit. Once it's admitted, then you can read from the document. All right. So today we covered, number 1, how to gather important evidence, even when you're not wanting to communicate or you're anticipating an outcome. And then we talked about disclosing that evidence, submitting it to the court as an exhibit for your hearing, and then how to introduce it as an exhibit at trial and get it admitted into evidence. All right, I hope you found that helpful. If you have any questions, put them down in the chat. I'm not able to give legal advice, so I may not interact with your question directly. However, if your question brings up an intriguing point, I could create a video about that question. So In the chat or in the comments below, put what state you're in, list your question, and let me know if you found this video helpful. All right. I'm wishing you so much success with your case. Thank you so much for tuning in, and I look forward to giving you more empowering legal information in the next video.